Sir, you are live now. We welcome you to the session, sir.
Thank you.
Sir, please start your session.
Okay, done. Good evening, friends. And I thank the TRD for organizing this topic on legal implications on the recent High Court judgment of Telangana on the TDR, basically. So there is a lot of confusion in GST era whether TDR is taxable under GST or not. If we see independently the provisions of GST and not mix it with the provisions of service tax, then it is definitely taxable. So before we get into the details of the judgment, how it's going to impact and all those things, I'll start the session now. In this session, we'll be discussing all those things. And here is a presentation what I have to do for you all. Yeah, for any law, it is very, very essential for us to understand the provisions in a GIF in detail, basically. We should read the provisions with an open eye, open mind. Since many of us are from the erstwhile tax regime also like central excise, service tax and VAT, we always have the hangover of the erstwhile taxes. That is a human tendency. But going forward, we cannot have such things in GST because it's almost 8 years for us. The rollout of GST has taken place and now notices have been issued for 17-18 and last date for passing of orders was 31st December 2023 and for 18-19 tomorrow, that is 30th April 2024, for orders to be passed for 18-19 issued under section 73. Now the question comes here is, when we read any provision, we need to read it with an open eye. And this is what we must have seen as a kid, the six blind man and the elephant. If you close your eyes and touch the tail of the elephant, we feel it is like a rope. If we touch the spear, if we touch the tusks, we feel it as a spear. The ears, we feel it as a fan. The legs, we feel it as a tree. So if you don't read it with an open eye, all these challenges are going to come. The only reason here why it is so critical and vital is the definition of supply. Definition of supply is given as an inclusive definition. The moment we say it is an inclusive, that means everything, anything under the sky, under the sun is falling under the scope of definition of supply. So we need to keep that in mind very, very carefully in GST. And it is the process as a professional, we need to learn, unlearn and relearn. If this is missing, then we cannot complete our task as a professional. When we say task, 100% delivery is not possible. And section 7 is here. We'll come back to on this. And before we get into this, we will understand what is JDA. The full form of JDA stands for Joint Development Agreement. So how many parties are involved in this? Two or more parties are involved in this, which is penetrating to a real estate project. Now we must have seen the concept of mutual funds. Small investors cannot go and invest in the stock market. They cannot monitor, they cannot manage the portfolio. That is why they go for the mutual funds. Similarly, in a JDA, multiple people will come together, pool the resources, expertise, and land for development of a commercial or a residential projects, basically. And when more than two people are involved, it is mandatory to have an agreement to avoid any future litigation. So an agreement is signed between all the parties, which will clearly tell the rights, obligations, duties, responsibilities of each and every individual. It also talks about how much a person has to invest, how much will be the marketing cost, who has to bear that, what will the construction cost, and if there is any profit sharing, what will be the ratio for that. So this is a comprehensive agreement between two or more parties who bring in land, and the other party will bring in expertise in construction and execution of the residential commercial project. And the agreement signed between the parties, the persons who are pooling the land, person or persons pooling the land, the person who is developing, is called joint development agreement. The persons who are giving the land are known as landowners. The person who is developing, executing, is known as developer. In most of the cases where I have come across and seen, the developer will be one and landowners can be multiple. So this is in nutshell what is a joint development agreement. Now the question comes, what is the necessity or need for a joint development agreement? Now let us say, for a small example, I own around 1,000 square yards of land in Greater Kailash. 1,000 square yards in Greater Kailash is a very decent chunk of land. Now the challenge comes for me is constructing it into a commercial or a residential. I need to put in investment. I need to monitor it. Then I need to monetize it. So investment is involved, monitoring is involved, and then comes monetization. The first one is the roadblock or the showstopper for many of us. I don't have sufficient funds to invest. A typical construction of a commercial project, a commercial office space costs anything between 2,600 to 3,100 rupees. Again, this varies from city to city and what is the type of construction material they use it. So I'm not getting to the depth of it. I'm just giving a ballpark figure. Now, I don't have money. That's a roadblock for me or a showstopper for me. There is another person who is into construction of these projects or this sort of facilities is doing it. He does not have the land bank, but he has money. So he approaches me. I will do construction for you. Let us get into a joint development agreement. I said, fine. When there is no investment, what should stop me? But my question comes, what is the vested interest for you to come and help me? Because in business, there is no concept of charity. Because he's incurring cost on behalf of me. That means in a business, the other person is expecting something from me. So in this case, the developer says, yes, I will put the investment, you put the land, whatever is the outcome of the project. Say if I get in that 1,000 square yards, if setback is removed, say I get 5 lakh square feet of land. Let's assume hypothetically. So in that 5 lakh square feet of land, let us share between 60-40. I'll get 60%, the developer will get 40%. So 3 lakhs and 2 lakhs. Or it can be portion of it. I'll give you 1 lakh, or I'll tell him you take 2.5 lakhs, but you give me some amount in cash. So that transaction can be structured in various ways. Or there can be cases where I will tell the developer, in case of residential or commercial, you sell on behalf of me, I'll give you commission. Because he's a developer, he has more access, more connects in the market, and he has good and wide marketing knowledge, so he can easily sell. So he will sell on behalf of me, I'll pay him some incentive or commission or marketing commission, whatever we call it. So this is how the modalities of a JDA works. Now, when it comes to JDA, the taxability comes into picture because of the supply definition, which is being inclusive in nature. If you read section 7, it says that supply includes all forms of sale, transfer, barter, exchange, lease, rental, license, disposal, agreed to be made for a consideration in the course or furtherance of a business. So since it is an inclusive definition, it can have any other form other than these 8 listed here. Whether you make that supply today or at a future date, agreed to be made at a future date for a consideration. This is the major difference here between service tax era and GST era. In service tax, we used to use the word money, but in GST, it has been replaced with the word consideration. Now, what is this consideration? In relation to supply of goods or services, consideration can be in cash or in kind. That's the chapter. That's the end of the chapter. Consideration can be in cash or in kind. So it can be cash or kind. I'll give you land, you give me developed property. I'll give you TV, you give me refrigerator. Kind. This is what it comes into picture. In the course or furtherance of business. That means it should be purely a business activity only. Now, we understood what is supply, what is JDA. Now, we also need to understand two other terms, because if you see the supply definition, it includes both transfer and barter. Now, what is transfer and what is barter? Barter, we have seen an example. I'll give you refrigerator, you give me television. That is barter. You're exchanging goods. There is no element of money in the transaction. That is barter. Now, when I'm giving refrigerator, you're giving me TV. That means it is a consideration. That means it is a supply under GST, because barter is covered under supply definition, plus for a consideration in lieu of refrigerator, TV is getting given for you. So this is how barter is coming into picture. So in service tax regime, we never had the concept of barter at all there. Then we have something called transfer. It's the right to use. It is only right to use, but there's no title of ownership getting transferred. So when I have a right, I can use it, but it is not my own. I take an office on rent. I have right to use. Do I become the owner of that office? No, because sale has not happened there. So there is a huge difference between transfer and barter and sale. And another important is service. Service is defined anything other than goods, other than money and securities, but includes activities relating to the use of money or its conversion. And actionable claim includes casinos, gambling, horse racing, lottery, or online money gaming. So whether the activity you're doing, is it a good or a service? When I'm transferring my land, it is treated as a service. Right to access, right to use is defined that transaction is classified as a service. And what is service? Anything other than goods. As a landowner, I'm transferring my land to the developer to construct it. I'm only transferring the rights. Still, the ownership is with me. That is why it cannot be treated as sale of goods. Now, in case of this one, who is going to pay GST? Because we have seen it is a transfer, GST is applicable. Now, whenever there is applicability of GST, either the buyer or the seller will pay. In this case, it will be the developer who will pay under reverse charge mechanism. Because for levy of tax and for a transaction to be qualified as a supply, all these 6 elements have to be taken care. First thing is it has to be qualified as a supply. There should be a consideration, there should be a value, there should be a determined tax rate, there should be a payment of tax, and time of supply should be there. So these are all essential before we get into the subject matter. Now, I'll show you a couple of points here basically. Now, since we are discussing about the one second. Yeah, sorry friends, there is a call from the department, so I have to take that call. So here I'll show you how we should verify the case loss in judgments, everything here basically. Yeah. So normally what I do is whenever I need to get into any judgment or something like that, you all know that we have various subscriptions like Taxman or Tax Guru or TaxCan or something like that, where we can have the judgment copies. Now we also have challenge. Sometimes we rely on the social media, whether it is a genuine case or not. Whatever we get in social media, we cannot rely on that. So normally what I do is I go to the case status of that particular high court or the Supreme Court, select the writ type. In the case what we are selecting, it is a writ application. So writ petition, I select it as writ petition and the case number is 5493 and it is filed in the year 2020 and enter the CAPTCHA code and I submit it here. See, it gives you the case history and everything. You can easily come to know what is the status of the case or anything actually for that matter. This is the beauty of Indian judiciary. Now it has been made online. I click on the order here. The judgment copy is here for me. The reason why I advocate this is maybe somebody must have played mischief. PDF editor is available in the market. They can change some content which may impact the case where we are representing this case basically. So that is the reason whenever I go for litigation, I always ensure to pick up the judgment copies from the judiciary portal only, so that I don't have any confusion at any given point of time. So I've already downloaded it. Let me take that for you all. So here is the judgment copy, and I've decided not to use any presentation in this case basically, because it will give you a hands-on experience on how to read the order copies given by the department from time to time. Now, if you see here, let me just zoom it a bit so that anybody can see it if they're using it from their mobile also. Yeah. So here, if you see, the petitioner has filed the writ petition. Now, the petitioners are the developers. They have filed the writ petition here basically. So if you see here, the relief sought for the instant writ petition is for direction by way of writ of mandamus declaring that transfer of development rights of land by the landowner to the petitioner by way of joint development agreements should be treated as sale of land by the landowners, and hence the execution of the said agreement should not be subject to levy of GST. Now you see here the petition has been filed on the genesis stating that whenever the landowner transfers the land to the developer, it should be under the joint development agreement. He says the petitioner says that it should be treated as a sale of land. Why he's telling it should be treated as sale of land? Because sale of land exclusively says is part of my schedule 3 entry 5, which says that neither it is supply of goods nor services, which means that GST does not attract. That is the reason the writ petition has been filed. Now the bug does not stop here actually. And it also says that notification number 4 of 2018 rates dated 39/2000 GST on transfer development rights by the landowners and JDA is ultra virus of the Constitution of India. See, even the notification which has been issued says it is ultra virus. That means it is not as per the constitutional provisions. When anything is ultra virus, then tax cannot be levied. This is the ground on which the petitioner is contesting. So petitioner here is Parita Constructions and the landowners are Jitwa Land Limited and Janinan Marine Properties Private Limited. So these two guys have 8.3 acres and 1.2 acres of land in the prime city, that is the high-tech city area, what we call it as Raidurg village, the knowledge city, and this space is given or taken over by Parita Constructions for construction of 3 office towers. And both the land put together is termed as composite supply. Sorry, scheduled property. So as we discussed in JDA, there will be two parties. One is the landowner, other one is the person who has the skill set, who has the expertise in construction. So the petitioner is an expert in construction of commercial properties. He is the developer. Now, why the petitioner says that JDA is to be exempted from GST because it has to be treated as sale of land. He says that JDA is technically almost like a sale of land, which has to be developed with the petitioner. It is further contended that the respondents cannot compel the petitioner to pay GST by treating the JDA and the consequences thereof as not a sale transaction of land. In this context, that petitioner intends to exercise the notification under challenge in the present writ petition. See, if you see here carefully, the petitioner never used the word as it is sale of land. He used the word almost like a sale of land. There is a difference, right? JDA, it is not treated as sale of land. They're telling that it is like a sale of land. Because it is like sale of land, GST should not be levied on the transfer of development rights. Like a sale of land is the word they have used it. Now the petitioner further says that the original landowner in fact transferred the development rights to the subject property to the petitioner. See, if I'm giving my land for some development, that means I should give him the right to access the property because he will go to different departments on behalf of me and he will get the permissions and approvals. So that is why the petitioner says that it is, since he is having access to the land, he is getting the approvals for the development, it should be treated as sale of land. The moment we treat it as a sale of land, it will be exempted from the levy of GST. Now, that is the backdrop and the two questions raised by the petitioner. Whether the transfer of development right is in nature of a transfer of immutable property or the nature of a service would fall within the scope of GST. TDR, transfer of development rights, is in nature of a transfer of immutable property or nature of services that would fall within the scope of GST. Or can transfer of development rights can be safely brought within the purview of an outright sale of land? So these are the two questions raised by the petitioner. Now the petitioner says that the notification number is ultra virus of Article 14, right to business, Article 246A and Article 265 of the Constitution of India. And it further says that particularly for the reason that the said notification does not prescribe any methodology or offer development rights, thus it becomes arbitrary and also unconstitutional. It is also contended that the said notification has been issued without there being any logical reason for issuance of the same. It is also irrational, unreasonable against the tenets of the law. Therefore, it is liable to be quashed. So normally when we put any replies or file an appeal, we use all this language just to put that this is totally outside the purview of GST or it is not falling within the definition or something like that. So that is what the petitioner has also used that language here. Now, why the developer is calling it a sale of a land? Because once the transfer is happening, the net impact is the execution of the JDA. Today, what happens is whenever there is a joint development agreement, suppose I'm the landowner, X is the developer, and Y is the buyer. Now, let us assume the ratio between me and the developer is 60-40. I'll get 60%, 40% is the developer. Now, the developer will not retain his portion, he will sell it to Y. Now, X, when he sells to Y, he can sell it only if the property is in the name of X. But if I transfer it in the name of developer, that is X, stamp duty is attracted. And when X sells it to Y, again stamp duty is attracted. So for one transaction, stamp duty has to be paid twice. So what happens is there will be a tri-party agreement which says that X will purchase land from me and he'll transfer the title deed to Y. So in this way, stamp duty is saved because the petitioner says that ultimately it amounts to the sale of land. It has to be exempted from the levy of GST because sale of land is falling under Schedule 3, Clause 5. It is not directly falling as sale of land, but is ultimately resulting in the sale of land. That is why transfer of development rights has to be treated as sale of land. And he further says that the whole transaction has to be considered in totality, but not in bits and pieces. So that is what it says here, right? The JDAs are normally entered, enabling the landowners to sell the land and procure residential commercial apartments in lieu of such sale. That the landowners are given residential and commercial apartments corresponding to the value of property sold to the developer, and the JDS are to be viewed as a convenience as is accepted in other laws. Now, again, as we discussed, the council points out that the same thing again repeatedly. So we are keeping here as telling the same thing in different forms and fashion to stress that JDA on transfer of development rights, GST is not applicable. It is indirectly amounting to sale of land, which is falling under entry 5 of Schedule 3. It is to be exempted from the levy of GST. This is what is telling again and again. And he further says that it is not under the Constitution of India and the delegated legislative power, and none of the virtues of a law are satisfied with this. And another important point brought in by the petitioner is that though it talks about in that notification RCM is applicable on TDR, there is no specific valuation mechanism. That means on what value tax has to be paid. So that is the reason this notification has to be quashed. I also have another point raised by the petitioner. Now, after putting all these arguments, the petitioner has also brought in lot of judgments basically. Now, it is a Honorable Supreme Court judgment in the case of Rajasthan State Industrial Development and Investment Corporation versus Subhash Sindhi Cooperative Housing Society, Jaipur and others. He says that tax cannot be imposed by issue of a notification to support his argument. And he also brought in various other case laws. So this is what we normally do, right? When we file an appeal or file a writ petition, we give reference to the various case laws to give momentum or the support to our argument, basically. Now, ideally, when you refer to the case laws, it is always recommended to give the relevant paragraphs. But here, somehow it has been missed out. Now, till now, what we have seen is the petitioners counsel who is defending and saying that JDA or in JDA TDR amounts to the sale of land on that GST has not to be levied. And if that notification on levy of GST for tax rate cannot be done because the value is not determined or there is no mechanism to determine the value. And he gives the reference of the Supreme Court judgment also. Through a notification, tax cannot be levied. Now comes the respondents counsel. He clearly comes and walks in, says that this petition deserves to be dismissed as there is no substance in any part of the petitioner. He clearly comes and starts with a very aggressive argument. This petition does not require to be discussed. It has to be squashed. It is beyond the provisions of the law and it is as per the provisions and it is totally within the purview of the law. Now, The only important thing the respondents council has done is he did not pick up any loose points from the argument of the petitioner. He picked up relevant clauses of the JDA. Then he started presenting his arguments. So that is why we always say that in any litigation, contractual documents are the source and Bible. So tomorrow, if there is any dispute between the buyer and the seller, the contractual document which is signed between both the parties will help in the court of law. So whenever you sign any contract or agreement, please be aware of the intricacies of all the clauses mentioned there. So the first clause says that landowner 1 is the sole owner of the 8.3 acres of land. And it talks about the survey number, everything. And landowner 2 is the sole owner of the 1.82 acres of land. And it talks about the survey number and all those things. And it says that who is the developer? He is having experience in the business of conceptualizing, planning, constructing, and developing commercial real estate projects. And it further says that the landowners have approached the developer with a view to engage its services for developing the scheduled property as an IT, ITS, and commercial office project in accordance with the terms of this agreement. That means this developer is going to construct office space for commercial space, especially suitable for IT and ITS companies. So they have done due diligence and they have taken up the activity accordingly. Now comes the important clause here. Clause number 2.2. So there is a mutual obligation between the developer and the landowner. That is what it says. The landowners hereby irrevocably permit, grant, authorize the developer, its agents, servants, associates, and any other person claiming through or under it the exclusive right to enter upon the scheduled property on and from the effective date only for the purpose of developing the scheduled property subject to terms of this agreement. This is a very, very vital and important clause, which says that landowners are giving irrevocable rights for the developer, its workers, its vendors, or any person who is representing the developer to enter into the scheduled property only and in conjunction with the terms of this agreement. And why did the landowners grant this to the developers? That is what this reads here. The landowners have granted such permissive possession and authority to develop to the developer in pursuance of the terms of this agreement, and such permissive possession and authority to develop in one coupled with interest, since the developer will be incurring infrastructural costs and expenditure towards the development of the project, including but not limited to the costs for obtaining the approvals. So if a developer wants to construct any office building, he has to go and obtain approvals from the various stakeholders. And for that, he needs to have access to the right. The access to the right is given by the landowners to the developer. One is to get construction approvals in place. Other, to incur expenditure to complete the project as per the agreed terms. So here, if you see here, one more point has been added. It clearly says that mere access to the land does not mean to delivery of possession. Mere access to land does not mean a title of the ownership. And clause 5.3 says the developer shall achieve the project completion within 48 months, commencing from the project commencement, hereafter called the deadline. The parties further agree that developer shall be entitled for a grace period of 6 months, commencement from the deadline, without the developer being liable to landowner for any penalties or damages. That is 54 months from the project commencement date. And project commencement date hereafter referred to the default deadline date. So up to 54 months plus 6 months grace period, 60 months, there is no penalties for non-delivery. Friends, please note this point. This is very, very important. We'll come back to this point again. And what is the role of the developer is clearly given here in clause 6.1. So here landowner 1 will hand over 82% because if you put together and they're taking the percentage, that is what the landowner will give it to him. Landowners 2 share will be 17.98%. That is how they've derived the values here basically of the total cost. And like any other contractual agreement, there is also a force majeure clause here given here basically. Now, the respondents council has clearly read out the provisions, relevant provisions of the joint development agreement, and as clearly says that on reading the important clauses, nowhere it mentions that there is an outright sale of property in the name of the developer. And he further says that the ownership rights or the title rights are with the landowner only. So that is what if we read it out, JDA particularly the clause which are reproduced in the preceding paragraphs, it gives a clear indication that there is no outright sale of property in the name of the developer. Rather, it is a case where the conditions would clearly indicate that the ownership, the title rights are all retained by the landowner himself, and only when which the developer has is the execution of JDA so far as developing of land belonging to the landowner is concerned. So here the developer does not have any access to the ownership of the land. So here the respondent council clearly says that there is no reference to the sale of land. And since there is no reference to the sale of land and that notification number which the petitioner wants to be squashed, which says that is ultra virus and unconstitutional, says that it is within the purview of GST and Article 279A of the Constitution of India. Now, if you see here, the whole argument revolving around the points raised by the respondent is very clear. The terms and conditions which we discussed in the initial first 10 minutes, which are the key elements of a JDA, are also part of this agreement. It talks about the roles, responsibilities, and the timelines. If it is completed on time, then only it will be handed over by the landowner to the developer. In case if it is not completed on time, then the handover will not happen and the expenditure incurred with the developer will be foregone. So let's read this also. The parties have agreed that upon achieving the project phase 1, including but not limited to the handover of the landowner's share, including but not limited to the handing over the portion of the landowner's undivided share to the landowner to the delivery date, the developer shall be entitled to seek in favor of any of its nominees, subject to the terms of this agreement, a conveyance in the form of sale from the landowner of the developer of the undivided share in proportion to the completed tower and annexed building in the project, which is attributable to the development share as per the allocation agreement. The parties have further agreed that upon project completion, the developer shall be entitled to seek and receive in its favor and or in favor of any of its nominee, subject to terms of this agreement, a conveyance in form of sale from the landowner to the remaining proportionate developer of the undivided share. It is clarified that in the project is achieved contemporaneously, then the developer shall be entitled to receive conveyance in form of the entire developer UDS for the purpose of receiving the sale of the developer undivided share in accordance with the clause 6.1. Developer shall be entitled to execute all relevant deeds and documents, including sale deeds, conveyance deed, etc., on behalf of the landowner and admit the execution thereof for the purpose of registration before the jurisdictional sub-registrar of assurances by issuing the authorization provided by the landowners in terms of clause 17 herein. Further, at the request of the developer, the landowner shall furnish certificate from the statutory auditor confirming the developer UDS is classified as stock in trade in its current financials and there is no pending proceedings or liabilities in terms of section 281 of the Income Tax Act 1961 affecting the landowners prior to the conveyance of sale by the land. So here it says that the developer will be given his share of undeveloped share only on completion of the project. It can be to him directly or through any of his nominee. So here it talks about the example what we discussed, I being the landowner, X being the developer, Y being the buyer from X. So that is what it is discussed here. Now friends, still know what have we discussed? From any of the discussions or the arguments from the respondent or the respondent of the defense or the counsel or the respondent's counsel, Can you make anywhere that transfer of development agreement TDR in the JDA is to be treated as a sale? Practically, it does not mean sale. He's given access, enabling him to obtain approvals, enabling him to invest money, enabling him to construct, enabling the developer to complete, and enabling the developer to hand over. When it is enabling, does it mean complete access? The answer is big, big no. So when I have a transfer in my name, it does not mean that I am the title holder of that land. If it is to be treated as a sale, then it should not have clauses like it should be completed within 54 months plus 6 months grace period. If it is not completed, then the developer will forego all his investments. If I'm the owner, that means if I'm the developer, if I'm the owner of that land, then why will I agree to have such clauses in the agreement? Practically no, right? Whether if I'm the owner of the land, if I'm constructing myself, I can construct in 1 month or 1 year. That should not be a concern at all. But since the developer has only right to access, all these conditions are put in. In some cases, we also see that the developer pays goodwill to the landowner. In case if the project is not executed or completed within the time frame as discussed and signed in the JDA, the landowner will forfeit the goodwill amount also. Whatever investment is done, that is also forfeited. Or if the developer is not able to complete, brings in another developer. We have seen some cases like that also. In such cases, mutually agreed value will be transferred by the new developer to the old developer. Here mutually agreed by the landowner, the old developer, and the new developer. So this is what it clearly says, thus a clear picture of the fact that mere execution of JDA by itself would not mean that right title and ownership of the property or portion of this property stands transferred in the name of the petitioner or developer. Mere transfer does not mean that ownership is getting transferred. There are certain conditions, milestone stages which have to be crossed before which the petitioner would be entitled to have a certain element of right over the completed constructed area which has been agreed to be left at the disposal of the petitioner. But it does not mean that mere execution of a JDA would amount to transfer of right to the petitioner. So here it clearly says that mere transfer of ownership to access, mere transfer of access does not mean sale. So here the respondents council says that primarily considered that as decided in this agreement instant writ petition is whether the transfer of development rights of the immovable property of the landowner can be brought within the scope of GST. Reading the clauses of JDA reproduced in the preceding paragraphs would by itself reflect that the landowners have bundle of rights attached to the immovable property. One of the rights is of getting the property developed by engaging an agency of his choice on his terms and in manner deemed fit. So it clearly says that landowner has the ultimate control on the property of the land. He is the owner. He is the decision maker. He calls the shots. He is giving only the access, nothing beyond that. And it also says that JDA itself has a clause which deals with a situation in any default on part of the petitioner is not timely completion of project or any other conditions stipulated or any breach of the conditions referred in the said JDA. There is also a condition of cancelling the contract agreement, under which situation the entire rights, the said property would continue to remain with the landowners. See, we also talked about, right, the terms and conditions, 60 months and all those things. If developer is not able to do that, the transfer, whatever rights is transferred, will go back to the landowner, which means that it is not sale. It is only transfer of development rights. And if you read the clauses 6.7 and 6.1, this paragraph, clause 27, clearly explains the modus operandi or the mechanism when it gets transferred to the developer on completion of the project. This is where on completion of the project, as per the terms and terms of agreement in the JDA, the landowner will transfer the undivided share of the developer's land to him or any of his references through a conveyance deed. This we discussed, right? To save the stamp duty cost. So here again, the respondent counsel says that JDA eventually results in sale of land is incorrect and misleading. It says it is done only through a separate convenience deed, that too after completion of the development activity. The undivided share to the extent of the petitioner is entitled could be transferred and not solely by virtue of JDA. Thus, the execution of JDA between the two parties by itself would not amount to result in transfer of ownership. The transfer of development right is hence a service under GST law, which landowner is offering to the developer, and that too for a consideration. Thus, transfer of development rights is a service and not an outright sale of an immovable property. So the argument put forth by the petitioner's counsel has been totally whitewashed here. It says that after completion of the project, as per the terms and conditions, then only undivided share will be transferred through a conveyance deed. That means this is happening only after completion of the development activity. Before that, it is not happening. That means it is not to be treated as a sale of immovable property, but rather it has to be treated as a service under GST law. That is where the landowner is offering the developer a service of construction for him basically. And consideration for him is in kind. That is transfer of undivided share of his share basically. And he further contends that from the plain reading of the JDA that was entered into between two parties, what is apparently visible is that there was no outright sale of land being effectuated, and the JDA per se cannot be considered as merely as a medium adopted by the landowner selling his land, and the JDA does not lead to sale of land by itself. After the entire development activities are carried out of that, investment is made by the petitioner for realizing what has been invested, he would be permitted to sell, dispose of certain developed properties constructed in execution of the JDA. In the said circumstances, the petitioner, though, has the right to realize the money from the sale of developed property, but the eventual transfer of developed constructed property, including undivided share of land in favor of the purchaser of the constructed property, will happen only after transfer of undivided share of land by the landowner by way of sale deed. Now, this clearly shows that the transfer of undivided share is happening only after meeting all conditions of the JDA in favor of the developer's buyer, that too through execution of a sale deed. And he also brings in one more point. Because of the virtue of the execution of the sale deed by the developer, the ownership is getting directly transferred to the purchaser and not in favor of the petitioner. If it is not transferred in the name of the petitioner, then how can it be treated as a sale of land? And the circular referenced by the petitioner is of no use. That is what the respondent says here. Respondent's counsel says here. And tax will be levied under reverse charge mechanism. So that is what is given in para 33. As per the GST Council recommendations, the liability to pay GST on supply of TDR shall be shifted to the developer promoter under reverse charge and was notified by notification number 5 of 2019, dated 29/3/2019. Under reverse charge, only the person required to deposit tax and report it in return is charged. The eventual burden to bear tax remains same with the service recipient, that is the developer promoter. Now, if you see the whole JDA mechanism, to understand whether it is taxable or not, we need to split it into the multiple legs. The first leg in the JDA is between transfer of land between the developer to the from the landowner to the developer. The second leg is construction service provided by the developer to the landlord. Then comes the third, sale of land. So in a JDA, typically a development agreement, there are two legs of the transaction. One is landowner giving right to the developer to access his premises, get approvals, construct it within the terms and conditions as agreed per the JDA. The developer will do the construction activity and complete it as per the terms and conditions of the JDA. So these are two different legs of the JDA, and these two legs are not falling under sale of land. There are independently transactions and qualified as service under GST and GST is applicable on these two transactions because there is a supply, transfer, transfer of land, barter, land is given, constructed property is given. That is again meeting the provisions of section 7, what we read earlier in the initial discussion. And construction services is qualified as a service under schedule 2 under entry 5B. Now, the Respondents Council is referring to the Supreme Court judgment in case of Commissioner of Income Tax versus Balbir Singh Maini through dealing with the provisions of Income Tax Act, but under similar factual backdrop. See here, when we refer to the judgments, we always refer to the jurisprudence basically. It may not fit directly, but the overall scheme may fit. That is where we refer to the allied laws, and when we draft notices or file appeal, we give into those considerations also. Just let me read it out for you all basically. A plain reading of the JDA shows that it is essential an agreement to facilitate development of 21.2 acres so that the developers build at their own cost after obtaining necessary approvals, flats of a given size, some of which were to be handed over to the members of the society. Payments were also to be made by the developer to the each member in addition to giving each member a certain number of flats depending upon the size of the member's plot that was handed over. What is important to bear in mind is that the payment under the third installment were only to be made after grant of approvals and not otherwise. That too, it is an admitted position that was never done because of no approvals could be obtained in the High Court, ultimately interdictated to the project. Also, the termination clause is also great significance because it shows that in event of JDA being terminated, wherever parcels of land have already been conveyed will stand conveyed, but that no other conveyance of the remaining land would take place. The object of section 2 subsection 47 clause 6 appears to bring in within the tax net a de facto transfer of any immovable property. The expression enabling the enjoyment of takes over color from the earlier expression transferring. That it is clear that any transformation which enables the enjoyment of immovable property must be enjoyment as a perpetuated owner thereof. The idea is to bring within the tax net transactions where though the title may not be transferred in law, there is a substance in transfer of title in fact. A reading of the JDA in the present case would show that the owner continues to be the owner throughout the agreement and also at no stage perpetuated to the transfer of rights akin to the ownership, and that too for a specific position alone is given under the agreement, and that too for a specific purpose. The purpose being to develop the property as envisaged by all the parties. We are therefore in the view that this clause will also not drop in the present transaction. So if you see here, paragraph number 26 here, the transfer is given for a specific purpose and it is given under an agreement. And what is the purpose is to develop the property. So mere transfer of land does not amount to sale of land. That is what the Defense Counsel wanted to say, and that has been well articulated through this judgment. Now again, the Respondents Council is going back to clauses and says that automatic transfer of ownership is not happening through the execution of JDA. It is happening only on completion of the project. And issuance of a completion certificate, the petitioner deserves the right to sell the area of property which stood allocated to him for realization of the JDA. So the defense respondents counsel further says that has been held that earlier under no circumstances can be can the execution of the JDA to a mere transfer of development rights nor any clauses of the JDA indicate that automatic transfer of ownership or title of rights over the any portion of the land belonging to the landowner in favor of the petitioner developer. In absence of any cogent and substantial material to establish the right, title and ownership being created in favor of the petitioner developer, the transfer of development rights stands amenable to GST and cannot be brought within the purview of entry 5 of the schedule 5. So ultimately the petitioner's writ petition gets cancelled with this paragraph here, paragraph number 39. All the important clauses what we discussed initially have been recapitulated here and says that the ownership is happening only after completion. And mere signing of a JDA does not amount to transfer of ownership. That means it will not be part of entry 5 of schedule 5, schedule 3, sorry. So based on all these arguments, the writ petition is not sustainable and it has been dismissed, which means that under GST on transfer of development rights, GST is applicable. So friends, this is what I have to discuss with you all. If you have any queries, we can take it up. This time I've intentionally not used the presentation because I wanted to go through each clause of the judgment basically. Yes, friends, now the floor is open for Q&A. If any questions are there, we can take it up. If JDA is fully executed in cash, can it be considered as a deemed sale and no GST on JDA? Sir, two things here again. If JDA is executed in cash, what is the developer offering? Construction service. Construction service is under GST, on that GST is applicable, sir. The resultant is transfer of undeveloped share. That's what we should not forget. Here, the developer is offering the construction services. So whether the construction services are offered in kind or cash does not matter, sir. Yes, sir. Any other questions? Any other questions, friends? Yes, we will share the presentation and the case law to the organizers and they'll share it with you all. Can somebody confirm if my voice is audible?
Civil, sir.
Yes, friends, any questions? You can chat here basically, then we'll respond to you. Uh, As there are no questions now, I hand over the session to the organizers, and I thank the TRD for giving this opportunity to share my views on the crucial judgment of the Telangana High Court on the transfer development rights with respect to the JDA. Okay, then we are winding up the session. Thank you, friends.
Thank you, sir.
Thank you.